Okay, I think we can get going, and if there's some others that are going to be joining us, then we have our staff that can admit people as we're proceeding. So, welcome again. Thank you to everybody for attending our Getz Collins webinar today. The topic, as you're aware, is managing employee performance and conduct in the workplace. My name is Colby Erickson. I'm an employment lawyer with our firm, and I also have a general litigation practice. And presenting with myself today is my colleague, Erin Gelhaus. And she also is an employment lawyer with our firm and also has practice areas in real estate and wills and estates. As we go through the presentation today, if you do have any questions, we'd welcome you to enter those questions in the Q&A function, which you should see at the top of your screen on the MS Teams program. And we're gonna field any questions at the end of the presentation, so you can enter them in there, and we will go through the list at the end, or you can feel free to hold your questions until the end as well, and we'll be happy to answer those. I do also just want to let everybody know that we are recording the presentation as well today. And so we will have a recording that will be available to view after if you have colleagues or anybody else that is not present, that or if even yourself, if you'd like to view the presentation a second time, then we will have that available for you. Okay, so without further ado, I'll get started here. And we're going to lay out a little bit of a roadmap for what the webinar will look like today. Sorry, I just need to switch to the next slide here. Okay, so this is how the webinar will be broken down. This is our agenda for the afternoon. So we're going to start by discussing some different strategies for managing employee performance and conduct in the workplace. And that can range from non-disciplinary strategies to obviously more formal disciplinary processes. Then we'll get into the concept of progressive discipline and performance improvement plans. And then at that point, I'm going to hand the presentation off to my colleague Erin, and she's going to provide some further detail on terminations, as well as human rights considerations and the duty to accommodate. So starting out with, and this is an overview of some different strategies when it comes to managing employee performance in the workplace. And we're going to start with the first topic, which is non-disciplinary strategies. And the goal when you're looking at managing employees' performance, the goal is really you're not looking to set somebody up for termination. The goal is always to try to maintain employees' performance at an acceptable level for the employer, so that you can hopefully keep those people employed in the long run. Turnover is expensive. Litigation is expensive if you have individuals pursuing wrongful dismissal lawsuits. So the goal is really to be proactive and keep employees' performance at a level where you can keep them employed in the long run, and both sides' goals are being met. So these are a couple strategies here that we've indicated, and this is obviously not exhaustive, but these are a couple strategies to proactively assist in tracking and managing your employees' performance in the long run, even if formal disciplinary procedures may not be necessary or even appropriate in the circumstances. So a couple of these examples are regular performance reviews, whether that be on a quarterly or a biannual basis, consistent coaching and feedback between managers, mentors, and their subordinates, as well as incentive programs which may reward employees for meeting performance objectives. And the benefit of using these types of non-disciplinary strategies is really twofold. The first is that hopefully, like I said before, it assists in maximizing the performance level of all your employees, so that you keep people employed in the long run. But the second objective is that in the event you do see performance start to become an issue with certain employees, where you do need to look at taking more serious disciplinary action, or potentially even looking at dismissing them from their employment, utilizing these more proactive non-disciplinary strategies will give you a longer snapshot or a longer history of that employee's performance, and you'll be able to see if that employee's performance was, below average for a longer period of time, even before you need to get to the point where you are engaging in more formal disciplinary processes. And so that's a good way to if you do get to that point and an employee is saying, well, I've been a good employee for the last 5 years or the last 10 years, then you'll have documented evidence in writing to show whether that's the case or not, and you'll be able to rely on that longer history. So moving into more formal disciplinary procedures, progressive discipline, this is a concept that's thrown around a lot in employment law, and it refers to the requirement that an employer must exhaust all alternative disciplinary measures before proceeding to more serious or more far-reaching consequences, such as a termination for cause. And so this concept is tied to the principle of proportionality. I don't want to step on Erin's toes because she's going to be talking a little bit more in depth about terminations for cause. But in most cases, a for-cause termination is probably not going to be a proportionate response to a one-off incident of misconduct. And this is where the requirement for progressive discipline comes into play. And so we're going to talk a little bit about what this will look like in practice. And so I've listed here on the slide a couple different examples of progressive discipline. And typically you start to see that in the first instance, it may be a verbal warning, then that may progress to a written reprimand and something that's a little bit more formal. And then even progressing to more serious matters where if you're having to investigate allegations of misconduct, you may have to look at putting an employee on a paid suspension or a paid leave of absence, or in certain cases, maybe even an unpaid leave of absence. You do want to exercise extreme caution with implementing any disciplinary measures that could be considered a substantial change to the conditions of that employee's job. And the risk there is that if there is a substantial change, for example, if you're placing that employee on an unpaid leave, if you're taking away that employee's responsibilities, if you're demoting that employee as a punishment for misconduct, that can be considered a substantial change, which may allow the employee to pursue a constructive dismissal claim, and that can potentially increase the risk or exposure to the company. So when you're implementing these types of progressive discipline, you do want to be very careful that it cannot be considered a substantial change that could open up the risk of a constructive dismissal claim. The last two there we have listed on the slide. So performance improvement plan, the dreaded PIP, that's another common example that's used by employers to communicate concerns and communicate to the employee what they need to do to improve and what the consequences may be if they don't. And we'll get into that in a little bit more detail. And then lastly, the duty to warn. So the case law in Canadian employment law is very clear that in most cases, before proceeding with a termination for cause, there does need to be a very clear warning as part of this progressive discipline process that the employee's job may be in jeopardy if they do not meet the employer's expectations, or they don't rectify the problematic conduct or performance concerns that have been communicated. And so on each occasion, when you do have to take any kind of disciplinary action, there should be a written record which you can rely on down the road if you need to. And that written record should include, obviously, the date of the incident or the misconduct, the reasons for the disciplinary action, which will provide in detail, what was the conduct that led to the need to discipline that employee. It should communicate the expectations moving forward and what needs to change. And there should also be an acknowledgement from the employee that they've received a copy of that document. And oftentimes you may get pushback because employees will perceive a signature as agreeing that that they're not denying the allegations. And so that's okay. They may not be willing to totally acknowledge that the discipline is warranted, but you should at least have them sign a copy to acknowledge that they've received it, and that they're aware that, of course, this is an issue from the employer's perspective, and these issues have been communicated to them, so they can't later, deny that they weren't aware, that they weren't informed of the reasons for the disciplinary action. So, what type of conduct warrants progressive discipline? And there's, again, this list is not exhaustive. There are probably endless types of incidents or types of misconduct that may warrant progressive discipline from the employer. But these are a couple common examples. And so the first one we've listed here is non-trivial violations of workplace policies or procedures. And obviously this one is made a lot easier if you do have clear policies and procedures in place that are in writing and that employees have reviewed and acknowledged that they've agreed to them. And so then it becomes much easier if you do have, frequent violations of those policies and you need to discipline employees, then it becomes much easier when you do have those written policies in place. Second one is, repeated absenteeism or lateness. If you have people not showing up for work without valid excuses, without proper justification. One of the things you do need to be careful on this one, and Aaron's going to get into this, as I said, on the human rights side of things and the duty to accommodate. You do want to be careful if the reason for the employee's absences is perhaps connected to a protected ground under human rights legislation that may trigger a duty to accommodate. But absent any of those considerations, of course, the employer has the right to discipline employees if they are not showing up for work or they're repeatedly late, that kind of thing. Insolence and insubordination is another common one, and something that should be addressed if it's happening on an ongoing basis. Inappropriate and unprofessional conduct, that's kind of a catch-all for a lot of these different types of workplace misconduct. And then even off-duty conduct that could harm the employer's reputation. That's something that we're seeing in the news right now with different political protests going on there, and there are certain cases where off-duty conduct can be grounds for discipline if it can be connected to potential harm toward the employer just due to their public reputation. And so those are a couple different examples of when progressive discipline may be necessary, when that misconduct probably isn't sufficient to proceed directly to a just cause termination, but you do need to document when these things happen. And one of the other concerns, if you don't document it, is that it can be considered condonation by the employer. You're essentially condoning that behavior if you're not taking any action to address it. And so you do want to make sure that there is something in writing documenting that this type of behavior is not being condoned, and it is subject to disciplinary action. Okay, so when is progressive discipline not appropriate? So this, and again, Aaron's going to get into this in more detail, but this is in cases where misconduct is very serious and very egregious. So at the very high end of the spectrum, when we're looking at the level of misconduct, and progressive discipline is not an absolute requirement, although it is going to be required in most cases. It's not an absolute requirement in every single case. And very severe, very egregious misconduct, even if it's an employee with no prior record of any disciplinary history, even if they've been an exemplary employee to that date, if it's sufficiently serious misconduct, even a one-time occurrence can be grounds to proceed with a termination for cause. And common examples would be misconduct which threatens the health and safety of other employees. So if you're looking at physical assault, sexual harassment, other behavior that may be considered criminal in nature, or serious conduct that goes to the heart of the trust required for the employment relationship, and that would be things like theft or misappropriation of funds. So these are the exception rather than the norm, but if it is conduct that's sufficiently serious, progressive discipline is not always necessary, and it may not even be appropriate, because in certain cases, you may actually be, as an employer, you may be opening yourself up to further liability from other employees if you're forcing them to continue working in an environment, with somebody who may be threatening their safety, or the health and safety of the work environment overall, which of course brings into play obligations under occupational health and safety legislation as well. So you do want to be wary of that. For very, very serious misconduct, progressive discipline may not be the way to go. Okay, so performance improvement plans. This is a form of progressive discipline, and usually this is further toward the end of the road when you've kind of exhausted all other options, and you're really looking at an employee where it's a case of chronic underperformance, and you've given warnings, you've engaged in performance reviews, coaching, feedback, nothing's worked, and you need to put the employee on a formal improvement plan that communicates. It needs to identify the concerns that the employee has or the employer has in detail, and what the expectations are moving forward. It should also outline the time frame for when the employer wants to see improvement, and that should be a reasonable period of time to give the worker enough time to actually improve and show the results of that improvement. And the PIP also needs to include a statement on the consequences for failure to meet these objectives. And so the consequence may be extension of the PIP for a certain period of time, or it may be termination for cause. And this goes back to the duty to warn under the progressive discipline approach. If you are going to proceed with a termination for cause, if you've tried everything, nothing's worked, and that's your only other option, you do need to have a clear warning in place that is usually communicated through a performance improvement plan, that if the performance does not happen within that specified time frame, and as long as that time frame is reasonable, then a termination for cause is a possibility, and that needs to be clearly communicated to the employee. Okay, so overall, the goals of performance management, as I stated at the outset, really the primary goal is to have the employer's expectations met and ultimately continue that employment relationship. The secondary goal is, if that's not possible, if you try everything and it doesn't work, then employers are going to be much more likely to be able to uphold a termination for cause if their performance improvement efforts are well documented through not only progressive discipline and performance improvement plans, but also through those non-disciplinary approaches that we talked about, performance reviews, incentive programs, that kind of thing. If you can show, the longer history you can show of underperformance, and the more you can show that you communicated to the employee what was required and they didn't meet those requirements, the more likely you're going to be able to uphold a just cause termination. And Aaron's going to get into the standard a little bit more, but the standard is really high. So it's really important that you're able to show as much documentation as possible. And the third overarching goal is just avoiding or minimizing the risk of exposure, the risk of liability to the company. And this really goes back to the first point of engaging in genuine efforts to help the employee improve and ultimately continue that relationship. And there's cases out there. There's a recent case out of BC, and we can put that in the chat if anybody's interested in reading it. But where employers engage in not genuine efforts, and they're really just using disciplinary measures as a box checking exercise to set up an employee for a just cause termination, courts will see through that pretty easily. And if those performance improvement efforts are not being undertaken in good faith and are not genuine, that can actually create a worse situation for the employer, and that can actually result in additional damages for bad faith treatment if the courts believe that the employer is essentially just disciplining an employee to to proceed with the termination for cause, and it really doesn't matter what the employee does. So you do want to be careful, and you do want to ensure that the efforts are genuine, because if they're too rushed or if they're too perfunctory and they're not really genuine, then it can make things actually worse for the employer. Okay, and that concludes my section. I'm going to hand it over to my colleague Erin, and she'll pick it up on the topic of terminations.
All right, great. Thanks, Colby. So sometimes, no matter what discipline or that you've undergone with your employee, you have nothing. Oh, sorry. I think I'm freezing. Colby, can you hear me all right?
Yeah, you're good, Erin. I can see you and I can hear you okay.
Okay, I'm sorry. My screen froze, so I was worried I'd lost everybody. Yeah, sometimes the you've done everything you possibly can, and at this point you are really looking at terminating. It is the realistic next step, and your last resort. So in Canada, there are two legal forms of termination. There's without cause, and for cause. Without cause, I mean, it means that an employer can terminate you at any time for any reason or no reason at all. So you're terminating somebody without an actual reason. There's no requirement to provide a reason. There are some obligations, though, to provide reasonable notice or payment in lieu, whether though that at minimum you have to meet employment standards minimums, or if the common law applies. That is a completely separate topic that we aren't really getting into today. And in the event of a without cause termination, the employee is entitled to employment insurance, so they can apply for EI. In a for cause situation, it is a highly punitive form of termination, being that the employee's employment ends immediately without any notice. There's no entitlement to any severance. So the only obligation the employer has is to compensate them for their time paid up to and including their last day. They're also not eligible for employment insurance, so they can't receive EI after being terminated. As Colby alluded to, it is a very high bar for employers, and the onus is on them. So it often can be very, very hard to prove, and the employer has to show there was sufficient grounds for cause. As a generally in employment law, we do advise our your clients to use it sparingly. A for cause termination, it should often just be reserved for very serious and egregious conduct that almost to the level of criminal. All right, so we're touch here a little bit on when a for cause termination may be appropriate. So like I said, it is reserved for the most serious instances of employee misconduct. The legal test is that it has to go to the root of the employment contract, and it fundamentally strikes at the employment relationship. So it renders the employment relationship irreparable. In Alberta, courts have become increasingly unwilling to rule in an employer's favor when just cause is alleged. This is likely due to the significant imbalance of power between the employer and employee relationship. Where an employer is found to have been wrongfully terminated, where an employer terminates somebody for cause and then the court says that it is not justified, a court can often award additional damages, including punitive damages, against that employer, in addition to any award for severance that employee might receive. All right. So in order to be successful in a valid for cause termination, you need to meet the legal test. So you have to show that there was an irreparable breakdown in the employment relationship due to some form of misconduct or omission by the employee, and you as the employer had no alternative but to end the employment relationship. The courts have come up with some specific grounds for valid for-cause terminations that they recognize. They include theft and dishonesty, workplace harassment and violence, gross negligence, a serious breach of company policy, assault or sexual assault that would be criminal in nature, poor performance, which is what we are going to focus on today. Other ones would be an unexcused absenteeism and lateness or criminal conduct. So those are recognized in the court as valid reasons to terminate someone for cause. However, there is a substantial amount of work required on the employer in order to prove these allegations. Okay, so when terminating an employee for cause as a result of poor performance, the test that has been consistently relied on by the courts to determine if it was justified is fivefold. So it's a five-step test. First, they have to show that there was a reasonable and articulated performance standard. So the employee is basically aware of what is being requested of them and what is required or expected of them. It was clearly communicated to that employee. I would advise that it be in writing, whether it's as part of your employment contract or a list of roles and responsibilities that clearly lay out the expectation. The employer has to give the employee suitable instructions in order to meet that standard. So the standard not only has to be reasonable, but you have to set the employee up to success to achieve this standard. Then the employee was incapable of missing it, and that you did provide the employee sufficient warnings that a failure to meet that standard would result in their dismissal. So number 5 is the most important. That's the duty to warn, which Colby had touched on, comes into play here if you are going to rely on a for-cause termination as a result of poor performance. The performance of an employee, these are just some important considerations on behalf for an employer to look at. The performance of an employee has to be grossly deficient in order to justify a termination without warning. So this would be an immediate dismissal. It's very, very high bar. It's unlikely that poor performance would ever really meet this. This is where that egregious conduct comes into play here. That's where an immediate termination may be more appropriate. The courts may consider whether the employee's incompetency, again, has to go to the heart of the employment relationship, such that the employment relationship is damaged. So the employer almost has to suffer as a result of the employee's behavior. And then again, did you provide the employee with ample warnings, both verbal and written, that their pattern of behavior or their continued performance are going to result in their termination if it continues? It also, you need to take into account that time is important here. You have to give them sufficient time to improve their performance before actually getting to the step where termination would be appropriate. An employer, when you're dealing with poor performance or some sort of misconduct where you're looking at a for-cause termination, an employer has an obligation to act swiftly. So once you're made aware of this misconduct that might constitute just cause, you have to elect whether you're going to take action, because if you don't, it could be considered that you've condoned the misconduct by allowing it to continue. Your decision has to be made within a reasonable time of learning of this misconduct. And if you don't act within a reasonable time and you allow it to persist, you cannot rely on it at a later date in order to justify a for-cause termination. You would need new facts to come into light that places a different complexion on the matter. So further misconduct on behalf of the employee might do just that. So if the acts are continuing, but they must be considered both individually and cumulatively. All right. So under our human rights laws, so employees may have a special needs related to an illness or various circumstances that fall under protected grounds that would maybe be responsible for some of this poor behavior that you would be considering terminating someone for cause. When considering these for cause terminations, it's important to understand how our human rights legislation is relevant and ensure that any termination doesn't trigger these protections for employees. In Alberta, the applicable legislation is the Alberta Human Rights Act. It provides that employees have a right to work in a workplace free from discrimination. It prohibits discriminatory employment practices on very specific grounds, which we will get into in the next slide. And it also deals with issues of discrimination arising in Alberta or based on actions of an organization in Alberta. So that's how to determine whether the Alberta Human Rights Act applies to you. There's also a federal Human Rights Act that applies to federally regulated employers. So it's important to discuss with your legal counsel to ensure which umbrella you fall under for that. So this is the list of protected grounds. There's 15 in total. It includes race, color, ancestry, place of origin, religious beliefs, gender, which includes pregnancy, sexual harassment, and gender identity, physical disability, mental disability, marital status, family status, source of income, and sexual orientation. So you want to consider whether your employee's poor performance may be a result of one of the above protected or one of these enumerated protected grounds. The most common ground when looking at performance issues that we see is usually mental and physical disability. So if an employee has a protected ground that you are aware of or you reasonably should be aware of, then you have a duty to accommodate that employee. So if the protected ground is a factor in the employee's poor performance issues, then you have a duty to make reasonable efforts to alter the workplace so that it is more suitable to the employee's needs in relation to their protected ground, to allow that employee to properly carry out their work duties. The standard is for the duty to accommodate is up to the point of undue hardship, which I'll go into in the next slide. However, there is no requirement for perfection. The courts understand that employers were not perfect. The standard is reasonable. It's a reasonable accommodation. Undue hardship, so it is defined as an excessive interference with business operations. It cannot be trivial. It has to be substantial. That's the key word. It's highly fact specific, meaning that it varies on the circumstances surrounding each employer and employee. What might be undue hardship for one employee might not be the same for a different employee under the same company. Examples of undue hardship would be a significant financial cost of the requested method of accommodation. So the accommodation that's required for this employee it's causing financial hardship to the company. Problems of morale with other employees. So the accommodation triggers morale issues amongst other employees. It has to be legitimate unfairness. So it can't just be an employee complaining because a different employee is getting different treatment or special treatment. As well as potential undue hardship would be if there was safety issues involved with the requested accommodation. All right. So in some cases, despite all reasonable efforts that you might make as an employer, the accommodation fails. So the employee is still unable to work and perform their responsibilities. If that was the case, then an employer's duty to accommodate does not restrict the employer from terminating that employer, or employee. You've done everything you possibly can, and if the accommodation still isn't working, you can terminate, and it would not be considered to be discriminatory. The key here is that you would have to show that the accommodation, the accommodation is virtually impossible to do, and that the employee is unable to perform essential work duties under the current roles and responsibilities. These work duties, they must be rationally connected to performing the job. So a lot of things in the news that have come out recently would be to accommodate an employee working from home. In order to state that accommodation isn't reasonable, it has to be rationally connected to working to performing the job. So an employee has to be in the office in order to successfully complete their job. And it also must be reasonable by denying that accommodation request. If you're able to successfully show that it is reasonable and that it is rationally connected to performing the job, then arguably any sort of termination or discipline would not amount to discrimination, notwithstanding this employee having a protected ground under the human rights legislation. All right, so I've pulled a couple of real world examples of some terminations that have gone all the way to court, and just to show you how the courts have dealt with them. This was a 2021 Alberta Court of Queen's Bench case, now Court of King's Bench. So this was a VP, he was a VP of finance. He was overseeing a merger of two companies, and he had made representations that he had extensive experience conducting these mergers. However, through the process of the merger, there was some significant issues. There was delays with financial reporting. The reporting was incorrect. It caused the merger to not go through. As a result, he was terminated for cause, and the employer alleged poor performance and incompetence. The court ultimately overturned the for-cause termination. They found there was a couple of reasons. One, the individual didn't have a proper job description or an employment agreement laying out his roles and responsibilities. The court found that the company failed to provide this employee with suitable instructions as to what was actually expected of him. And they never gave him the warning that his employment was at risk or an opportunity to correct the deficiencies that they believed exist. So this is where progressive discipline would have come into play here. And it also found that they failed to run a fair and impartial investigation. So they did conduct an investigation prior to terminating him. However, the investigation wasn't done impartially. So ultimately, the employer was entitled to his common law reasonable notice. So he was given 4 months of his total compensation, so not just base salary, as well as the court awarded damages for breach of good faith as a result of the for-cause termination. The total award was over $1 million. Here's a second example. So this employee, he was there for 4 years. His main responsibility was maintaining the company's certificate of recognition in order for them to remain in good standing in their industry. Ultimately, it lost their certification. And it was due to this employee. It was his responsibility why it was lost. So they did terminate him for cause. Confusingly, they also did provide him 1 month of salary. And they stated in his for-cause termination that his competence fell below standard, he failed to adequately perform his duties, and he also deceived or misled the company about the status of the certification. So he had lied and said he was applying for it when he actually wasn't. The employee at the time of his termination was suffering from a long-term illness. Ultimately, the court again overturned his for-cause termination. They found that at least up until the point that he became ill, he was performing his duties relatively well, and that the employer did not properly accommodate him in order to continue to allow him to perform his obligations once he made them aware of his illness. They didn't provide him with the necessary assistance that he needed. And also, the court noted that there was no incompetence or deception exhibited by the employee. At worst, he was naive in believing he could get the certification, and the naivety did not warrant a for-cause termination. So they said that there was likely a more progressive discipline that would have been warranted here rather than just terminating for cause. He was awarded 6 months common law notice and additional bad faith damages that the employer had to pay. So just some key takeaways from that. So terminations for cause, it is a very high bar to be successful in a termination for cause. They're highly fact specific, and the courts are very skeptical, specifically when it's related to poor performance. They often look instead for like gross misconduct is the level that they're putting for poor performance. The duty to warn in these situations is very important, and that duty should be well documented. And any discipline must be proportionate to the alleged misconduct. If you are going to proceed with a for-cause termination, just be wary of all these factors. A failure to meet that bar can result in not only you having to pay them their severance, so their reasonable notice, but there may be additional damages due and owing on top of that. That's it for me. That's the whole of the presentation. Right now, if anyone has any questions, what they can do is just pop them into the question or the Q&A chat, and we'll do our best between Colby and myself to answer them. If not, then as Colby mentioned, this will be made available to everyone. The recording, will be made available to everyone following the presentation. And if you have any specific questions, you can reach out to us individually. Our emails are just here on the screen. We're happy to answer any questions you might have that might come up after the fact. But I hope you found this helpful, and thank you for taking your lunch hour to join us.
Aaron, it looks like we have a couple questions in the chat here.
Oh, great.
I can take this first one. So the question, just for everyone's benefit, is a demotion a possible outcome of a performance improvement plan not being met? So in this case, my answer would typically be no. We would typically advise against a demotion as a potential consequence in that progressive discipline process. And the reason for that is it may expose the company to liability if the employee chooses to resign and claim constructive dismissal as a result of that. If they allege that demotion is a substantial change to the terms of their employment. And typically a demotion, if it is serious or if it is significant enough, that is usually considered grounds for a constructive dismissal claim. So we would typically advise against demotions. Usually you have to coach the employee to improve their performance in the role that they're already in. The one exception that came to mind as Aaron was presenting on the duty to accommodate, If you have an employee who is, maybe they're struggling because of their health condition, they're struggling with their health, or related to some other protected ground, and that's the reason why they're having difficulty performing to a satisfactory level. As part of that accommodation process, you can offer that an employee an alternative role that may be more suitable to their specific health condition. And I wouldn't frame that as, I wouldn't recommend characterizing that as a demotion, but I would recommend characterizing that as an accommodation that you're offering the employee as part of that required accommodation process.
And then there's another question. I think, Colby, this is probably geared towards you. Is there a time limit that documentation should be kept in an employee personnel file?
Sure, I can take that one. So the Employment Standards Code does have some specific requirements for record keeping for companies. That relates more to things like pay statements, that kind of stuff. You have to keep records of that for the prescribed periods of time. When it comes to documentation relating to discipline, there are no real requirements, but if we were advising you as your legal counsel, we would recommend keeping documentation for the longest time period possible, because if you are looking at, if you have an employee that you're dealing with chronic underperformance and it's a very long period of time, as we discussed during the presentation, the more documentation that you can show relating to those performance management, performance improvement efforts, the stronger case you're going to have for if you are going to try to proceed on a just cause termination, and particularly where you're dealing with poor performance, the cumulative impact of that poor performance is very important. And if you can show that they've been warned on numerous occasions over a period of 3-4 years or even longer, the more documentation you have, the better. With that being said, if you have a long-term employee who is, they've worked for the company for 25-30 years, and then you start to have performance issues, if there is documentation from 25 years ago, it probably doesn't carry much weight. If if they had some disciplinary concerns at the beginning, then they were fine for 20 years, then you have some more disciplinary concerns. The stuff from 20 years ago is not really going to carry too much weight when it comes to assessing their performance. But in general, as long as you have the capacity to do so, the more records you can preserve in the employee's file, the better.
Yeah, I was just gonna note, just to tag on to Colby's, I mean, if the past behavior is different from the current behavior, that's not something that you can necessarily continue to rely on, because you would have already disciplined that employee for that past behavior. And then if it's new, then you can't, it wouldn't be cumulative, because they would have arguably improved on that. And this is something new, which would require new progressive discipline. All right. I think that's everything.
Okay.
Okay.
Well, if anyone has follow-up questions on those two questions, or like Aaron said, if anyone has any additional questions, if you're not comfortable or you don't want to put it in the chat now, then feel free to reach out to us directly. But yeah, I think we can probably leave it at that, Aaron, unless you have anything else.
No, I'm good to go. Thank you, everyone, for joining us.
Thanks, everyone.